in brief, right, what's the contour of this particular subject, right, that we are going to learn about international law, the basics of international law, particularly, and there, thereupon an expectation has been formed that student will generally have the requisite course outcome, program outcomes, knowledge from the subject, right? Now, this first definition is something which has been coming time and again in your initial few years, right? You have already been, referred to this particular question many a times as to what is law. It started in the first lecture of your legal method as well. What is law? And the general conclusion that we have drawn from those subjects is that it is something which is very difficult to define. At least we have surety with respect to this fact. Do I have the CRs available here for this section? I have to write names as well. Any CR for this section? No, we don't. Chalo. Perfect. And I need to connect with you as well because there are in certain situations some prior intimation with respect to classes has to be informed because we are working on NAC as well, right? So there can be a possibility, and there is this Viva as well that we have to conduct, and I'm part of that particular board as well. So for those particular days, there might not be a class. So I need to inform you well in advance, right? So yeah, chalo. So we have been finding out this particular answer with respect to law. The general understanding has been that it has protein phase, right, which means various aspects and cannot be defined in few words, right? It can never be defined because it changes over the course of time. It has multiple aspects also referred, right, which include social, political, various issues. Nowadays, even technology has been playing a very important role with respect to creation of laws or for what we believe or meant by laws, right? So, but there are certain rules, certain uh, factors that affects and can be found commonly across the laws irrespective of a particular state. Now this is an important issue because ultimately on the basis of definition of a law we will be reaching into the definition of international law, right? So what we have understood is that there had been a lot of changes, and the idea which is commonly found across various this jurisdictions is that there has to be a legal order which is necessarily important to ensure that there is a stable existence of humankind, right? Or a legal order that supports interactions amongst the humans, right? Or with international institutions or with the governments of their particular state. So it is a very important aspect. Every society, now this particular second point is very important for us to understand because every society is having various parts, right? It can be a small society, it can be a large, it can be a powerful or a weak society. So is the case with respect to states, right? That's why I've been arguing this particular point for understanding the definition of law, connecting it with the society that we have in our own domain, and thereafterwards putting it in sync with the world altogether. So you have societies which have various aspect attached to them. They may be a society which is very powerful, weak, small, large. So is the case of states as well. There are states which are economically very powerful. There are states which do not have economic ability of the nature that has been found with other states. There are large states as well, and there are small states as well. Much like the constitution of any particular society in any municipal settings. So but laws teaches us certain aspects, right? It provides us a guidance as to what can be done and what should not be done, what is permissible act, what is forbidden act, right? And by and large formation of law has various aspects attached to it. Some believe that law has its roots to the state itself, the will of a state. Some believe it's a contractual agreement, right, which has been entered upon the people, a group of people. Some believe that it has nothing to do with this, but the morality itself. Some says that law has every roots to the reasons, right? Psychological schools. Some believe that law is being functioning in a particular society because of the roles of various important, these members, particularly the judges, the lawyers, and the framers of the constitution and the parliament, right? For that matter, they all constitute what we believe as law, right? Which is also correct. Then there is critical law school, which suggests that okay, law has its own, there is a justification to this particular argument that law brings out certain clarification, it brings out certain clarity to the state, right? And their importance is without any dispute. But critical legal theorists also argue that it is because of law that the problems in a particular society persist. So it is a problem solver, but at the same point of a time, it is also problem creator. So that's what is the critical legal studies. And that's why, if you can recollect it from the lesson plan that we have shared, we have used a particular point, critical analysis. And many a times, generally for this particular section or this semester, you might not have come across substantive, questions. Previously, they used to get this particular question across all the question papers, right? Critically analyze this. But we have not taught our students the critical analysis of it, which is what is important. And this is where critical legal theorists argue that teach your students law from the perspective that it can also have elements of, problems attached to it. Like, and they argue that there is this issue of race, critically race theory. They argue it from the perspective of feminism. They argue it from the perspective of postmodernism, right? All those concepts. So there are problems as well created by law. A classical example with respect to international law is that for countries like third world country and developing country, we always argue before international forums that the rules that has been prescribed on behalf of WTO, they are anti establishment of third world country or developing country. They are pro developed nations. This has by and large have been an argument that laws have been structured or designed in such a manner that it takes into consideration the aspects of those developed states alone, right? And that's a fight, right? You have various scholars from India itself who have been arguing this particular argument. Many of times you might have heard about Professor Bakshi, Professor Chimney, right? They argue it from their own perspectives. Bakshi arguing it from the perspective of human rights, Chimney arguing it from the perspective of refugee laws, all those things, right? Humanitarian law, refugee law, all those aspects. So, but anyways, the point is that we understand the value of law. We understand how law functions in a society. We understand the importance of law in ensuring that what can be done, what cannot be done, prohibitions and forbidden acts, right? So this is something which has already been understood with respect to the definition of law, right? Another important aspect of law is that it binds the member of community within a particular society. We all know that it is only because of law that we have been connected in a particular given society and ultimately forming it as a state altogether. So that's also important. Along with that, law lays down certain values and standards as well, right? Those values and standards collectively form part of the society itself, and those represent the society, right? So many a times you will have a different value setup of a particular state comparatively to the value setup of another state. Standards as well. Standards in a developed state are different to the standards that are available in the third world or developing state, right? Those are also varying with respect to the law, right? So it ensures that there are certain rights and duties. It helps in creation of contract, right? It ensures that infringement, if at all anywhere done, shall be answered accordingly, right? So this is what by and large you have referred from the last previous 4 or 5 semesters, right? Now you have also understood that it is a set of rules and regulations which regulates our behavior, governs our behavior, and it by and large provides the kind of society we live in, right? That's also plays a very important part. Now the same aspect which we have studied in our previous semesters pertaining to law, these guidelines, those rules, norms, principles that we have understood on the basis of understanding of a law can also be traced to international law. With just a small, addition to it, that all the elements of law which are present in the domestic setup, in the municipal setup, they have to be supported by the principal subject, like nation states. When state supports them, they become form part of international law. So you have this concept of res judicata, which is available in your domestic setup, but that's a principle which has also been acknowledged under international law because it has been acknowledged among the states. They have acknowledged it, they have recognized it, they feel that this particular concept is of some help across the states, right, and will be of some help across the states, right? There is no doubt with respect to their or its existence. Similarly, there are reference of word called us cogens, right? Those are words which have been referred. Us cogens means peremptory norms, norms from wherein you cannot have further derogation, commonly accepted by everyone, right? So pirates are common enemy of the world. Anywhere, any state catch holds of these sea pirates, they will have to be tried by that particular state according to its own domestic, criminal jurisprudence, right? There is no doubt with respect to this. There will not be any state who will be in support of those particular pirates, right? Otherwise, there will be other, sanctions that can be brought against such a state, right? Similarly, various other aspects that you should be aware, like principle of non reforma, which has obtained to a greatest extent the status of us cogens, right? Under refugee law, if there is a refugee who has been settled in a particular territory, you will not send him back unless and until situations have been better, right? Because there is a fear of persecution for which that particular refugee has sought the relief of a particular state. So it's a responsibility of that particular state that his life is not threatened by that particular fear of prosecution, must not be returned back to its original native place, right? You have to provide necessary guidance. And this is an important aspect. Be part of any particular convention, treaty, or protocol. Even if you are not part of it, you have to take care of those particular principles because it has attained the status of jus cogens, right? The general rule, the peremptory rules for which no derogation is expected. No state will deny their existence, right? Those particular jus cogens. So the elements that were available in the definition of law that we have studied over the course of a time in the domestic setup have their reflection in international, provided they have been backed by state, right? State recognizes them and thereafterwards acknowledges that it is binding upon themselves. That becomes by and large the wider understanding of. I didn't get that. Could you try again? Yeah, just a second. That's what I thought. So that's what becomes part of the international law, right? So there are many contrasts between law of any particular state. You will have a state A which has a different criminal setup comparatively to a state B which has different, right? Those are forming part of municipal laws itself. So a criminal law which is part of a particular state itself is its own domain. They can frame those laws. No state can compel them that we have a different setup of our own criminal jurisprudence. Please enforce it upon to your own territory as well. No state can deny that particular aspect because the threshold of international law is that each state is considered as sovereign, right? We function from that particular threshold. So whatever these principles, norms, guidelines you will have, you will find their reflection in this particular threshold that each state has been treated as sovereign. Their agreement or their acknowledgement or their acceptance to a particular rule is inclusive of this particular right that they have been treated as sovereign. So if we'll put them in a position wherein the sovereignty of a particular state is undermined, the state is all the more, like free to move out from such particular treaties, right? But there are repercussions that customary international law or jus cogens must not be disregarded. So no state can deny the fact that there is a established customary international law. It has to be acknowledged. Or no state can deny this particular aspect that there is no jus cogens, preempting norms, right? We will not be binded by that particular preempting norms. That cannot be defined, right? So international law is further divided into two parts. One is your private international law, and the second one is your public international law. Private international law is conflict of laws, right? You have a specific contract act. That doesn't mean that the similar kind of contract act would be prevailing in parts of other states, right? Say, for example, France has similar contract. So if there is any ambiguity with respect to the contract that has been entered between the citizens of France or with the India, or for that matter, a company in France or with India, or for that matter, an Indian, like a citizen with the state of France, those will be defined, will be corrected in private international law, which is conflict of laws. When you have issues with respect to the implementation of the laws, then those will be settled distinctly within the concept of private international law. So that will not be the domain of international law that we are going to study, right? What we are generally going to study in this particular semester is public international law, which is laws, norms, rules, regulations, guidelines that has been recognized and has been treated as binding upon the states. States are party to those particular treaties. You will not find reference of an individual. You will not find reference of any other entity other than what is not within the meaning of subjects of international law. Right? So state have acknowledged it. It is only on the basis of acceptance of state those particular rules have been established. That forms part of public international law, or what we call is law of nations. Right? Jus gentium. That's the Roman word which has been used with respect to public international law. Jus gentium, not jus inter gentes. Right? It's part of agreements law. The conflict with respect to implementation of that particular law, and in fact, with respect to that, you have already studied CPC, right? In previous semester, there is a specific provision that allows enforcement of foreign degrees. So, in issues pertaining to conflict of laws, you will have your own mechanism, right? There's that subject you will be studying later on in the ninth semester, and you will have more clarity over there. So, if there is an issue with respect to implementation of a law, private international law, when there is concerns which are of between the states, public international law comes into picture, right? So that's what is the aspect pertaining to this. Now, public international law covers relationships, right? You will have laws pertaining to diplomacy. You will have laws pertaining to, wars, human rights, for that matter, various domains, air and space law as well, right? That's a new emerging subject. Though it's not part of our syllabus, we have only law of sea. That's also part of states because states have been proclaiming their jurisdiction over the outer space, and this has to be regulated. It has to be regulated in a manner that the sovereignty of each state, concerned state, is not undermined. That also forms part of it. Wherever there will be involvement of states, you will have reference of public international law, right? This is either universal or general, right? Universal means customary international law or jus cogens. General means treaty specific. All those countries which are part of that particular treaties, that will be applicable only upon those particular states, unless and until the treaties have attained the status of customary international law, or they have been considered as part of jus cogens, right? Then it will be applicable upon other states as well. I have already given you the example, principle of non-refoulement, right? It is part of the Convention on Refugee Status, right? But it has obtained a status of jus cogens, a peremptory norms, which has to be accepted by every state, irrespective of the fact whether they have been acknowledging it or they have been concerned, like they have been treating it as a binding principle upon themselves. Binding only when you are part of any particular convention, declaration, you have been signatory to that, and accordingly transformed into your own domestic system, right? Through ratification, right? So it is, say, for example, India is part of many international treaties. By and large, if you look into the status of Indian state with respect to international law, we have been following all the principles of international law. Every convention, it will be hard to find out a convention wherein India is not involved, at least in terms of signatory. Whether we have ratified that particular convention into our own domestic sphere, that's a matter altogether different, right? We need not have to dwell into that particular aspect. More in detail, you will learn when, as and when you will develop more interest into this particular subject. But India, by and large, you can be assured enough that it is part of every treaty, including Moon Treaty, right? You can just Google out that treaty. It has hardly around 15 members. India and Pakistan are available in that particular treaty, which has very little relevance, but still it is the treaty which is available, right? In fact, with respect to law of sea also, right? In the initial few years, states were reluctant to be part of that particular convention, law of sea UNCLOS, right? It took significantly more than 10 years for its application, because there was a specific clause which says that the threshold of this many number of states are required for enforcement of this particular convention, right? So it's very interesting. That's why we will be learning about it more in detail when we'll come to unit 3, right? So universal and general, right? Regional as well. You have regional specific organizations, African Union, you have European Union, you have ASEAN, BRICS, right? We have our own SARC as well, right? So all these are regional specific as well, right? Wherein group of states who are linked geographically, ideologically you have NATO, example, prime example of states coming together, forming part of that particular like group, so as to take care of the interest that has been assigned over there. So it can be geographically, say for example, SARC, South Asian, right? It can be ideologically as well, right? So they recognize, when the state recognizes certain things, either generally or universally. Universal treaties are like your Geneva Conventions, your UN Charter, right? Many other aspects like ICCPR, ICESCR. CPR means civil and political right, economic, social, and cultural right, ESCR, right? All those things. Convention on Rights of Child, CEDA provisions, right? Convention with respect to women, all those things. So, and this is interesting. And the international law developed from those particular alignments, right? Say, for example, this practice of diplomatic asylum. This was a practice which was not accepted across the world for a greater part of the history, its history. But because of its common practice followed in South America, right, Latin America, it was realized that this is something which needs to be worked upon. And accordingly, you had those diplomatic treaties, right? Consular diplomatic treaties. The issue pertaining to asylum developed since then, right? It is still in its nascent stage, not comparatively to what was felt at one point of a time, but there are progresses which have been made, right, in this particular regard. So there is this particular problem. We can just solve this particular problem so as to understand the distinction between what is private international law and what is public international law. This will give you more clarity. Now, issues with respect to adoption. Where will you put adoption? Under PI, private international law, or a public international law?
Private international law.
Okay.
Private international.
Yeah. Arms control.
Public
Public.
international law.
Public international law. Right. Any example with respect to this? There is a nuclear treaty, right? That is specifically amongst the states in order to have proper use of this particular technology, right? Nuclear technology is a technology that is helpful for the humans, and it has always been argued that it is only going to help the cause of humans, but it has its evil side as well, right? Contractual relations,
Private.
private, perfect. Divorce,
Private international.
perfect. Environmental issues,
Public.
Public international.
Public.
yes. Human rights,
Public international.
Public.
Public.
yes. Immigration laws,
Public.
public international law, yes. International crime,
Public.
Public international.
yes. Maritime law,
Public.
Public international.
Public.
yes. Piracy,
Public international.
again public international law. War crimes,
Public.
public, right? Asylum,
Public international law.
yes. So by and large, we have understood that when we are talking about private international law, those are laws in conflict between two states, domestic laws in conflict. So we have our law pertaining to marriage. They will also have their law pertaining to marriage. Each state will have it, right? But if there is a conflict between the laws of two particular states, those will be settled by private international law, right? There is Hague Convention with respect to this, right? If there is an issue with respect to contractual relations agreements, you also have contractual laws in your states. They will also have, and if there is any conflict between with respect to its jurisdiction, with respect to the clear meaning of that particular term over there, you will have involvement of private international law over there, right? State has accepted that, like issues pertaining to jurisdiction has to be dealt differently, right? That's not a matter of state altogether. The conflict of each of those particular laws has to be dealt differently. But when it comes to matters which are connected with state itself and have parties or like referred as state over there, those are part of public international law. State have agreed that they want to control arms. They want to have a common consensus with respect to environmental issues or with respect to human rights issues. They will develop like necessary immigration laws, right? So all of those particular aspects have been dealt under public international law, right? Asylums and all those things. But at this point of a time, we also have to distinguish further a few things, right? What is international law? We have understood. What is this scope pertaining to public international law? We have understood. But there are certain aspects which are of irrelevant, right? Irrelevant for a student of international law at this point of a time, because you are learning the basics of it, right? So you need not have to confuse your understanding of international law with international comity. What is international comity? It is basically certain sets of protocols that have been agreed by a state or amongst the state, that the head of a state will be received by the head of another state, right? So there are protocols with it. But there are certain situations wherein a head of a state is not received by the head of our state, right? But that doesn't mean that it is in violation of any particular international rule. There is a different aspect of it, right? International community, because one of the essential second threshold which I will suggest to you at this point of a time for understanding of international law, one is states are sovereign. That's the basic, right? So whenever you are studying international law, please understand that it is on the ground, laid down on the ground, that state have been considered as a sovereign entity. Second important aspect is that there is this concept of principle of reciprocity that functions very much importantly in international law. So if you will treat my head of a state with equal amount of respect, the same will be expected from the other state. So there's no such rule as such laid down under international law that you need to salute the flag of another state. But we generally see that states, heads of the states or members of the the government of a particular state do so, provided they've been part of any international meetings or with respect to any other such aspects, engagements for that matter, right? But as such, there is no such rule. But again, understand it from the concept of principle of reciprocity. If you will not respect my flag, possibilities are high enough that we will also not be respecting your flag. Right? These are sentiments. So international law is not just about the laws that have been agreed upon the people. There are certain sentiments also attached to it, which is by and large clubbed within the meaning of international comity. We all are same. We all will respect everyone same. Right? There are always exceptions to this particular rule. Another important aspect is what many scholars of international law argue is that it must not be confused with international morality. Right? And we have plethoras of example with respect to this from Austin holding that there is no such concept of international morality. It is of lesser importance because state as sovereign cannot listen to another sovereign. And if there is a sovereign which listens to other sovereign, his sovereignty is in question, right? But by and large, this is also an argument which is famously been between the two schools, right? The positive law school arguing that law is supreme, the natural law school arguing that laws are in a way products of morality, right? So you have this Law and Fuller and HLA Hart, right? So there is this Hart versus Fuller debate with respect to law versus morality. Right? Just if you have not covered this particular aspect in the earlier classes, go through the Google. There are various YouTube videos as well because this is something which is expected from every law student to have at least some idea about, right? Hart versus Fuller debate, which is between law and morality. And this is something which is also there in the international law. There are scholars like Malcolm and Shaw who suggest that these must be distinguished, must not be clubbed together. But there are other scholars who say that like even international law have this issue of morality attached to it, and even the international law that has been produced, those are all with respect to the moral obligation that state ought to have against the or with the other state, right? The human rights, it's all because of morality argument that we should be protecting the interest not just of ours but as well as the interest of individuals irrespective of their nationality. They should be provided with those particular human rights, right? So say for example torture, right? Another example with respect to Uzcogins, because I was referring to that particular example, is slavery. No state across the world will accept or have any law that will support slavery, right? So it forms part of Uzcogins, not customary international law. Customary international law and Uzcogins have to be understood distinctly, and we will learn that particular aspect in coming classes, right? So slavery is another example because that came to my mind when I was discussing about this issue of morality. For that, yeah, okay. So this is also what they have argued that must not be clubbed. But then there are, like arguments that you cannot devoid law from morality. More so with respect to international law as well, because morality brings out values, it brings out ethical arguments, right? Moral arguments. So those are all essential for understanding of international law as well. So, but what is important is even with respect to this international committee as well, I said that the principle is reciprocity. So if you believe in that particular principle, you will actually put international committee within the meaning of international law. But if it doesn't believe in that particular aspect, it is of no help, right? So international law must be distinguished from these two aspects. Now, this is something which we have already discussed in the previous introductory class. Just imagine situations wherein you have been, or your like day-to-day activities have been greatly influenced by international law, right? And think upon it. And if you have any difficulty in understanding it, we can discuss upon those particular aspects. Because now, in this particular class, you have to understand that everything and anything that you've been performing in your daily day-to-day livings, those are all influenced by the structure of international law, right? And there are various examples to it. So to which I will suggest that you just look upon them, right? Now we have international systems as well. This is something which I've already informed that it differs from state-based legal systems. In state, you have civil courts, you have criminal courts, you have tribunals, you have special courts, right? Now, what is the difference between a special court and a tribunal? Just find out right? Because many a times when I will be discussing about a particular subject, I will be putting these questions just to get, like bring out more clarity to yourself, because you have come across the term tribunal, special court. What's the difference between these two? Those are not regular courts, of course, right? So it must not be this particular distinction, but the basic distinction between the two. Just try to find out that particular distinction. Okay. So international law has a different legal setup, right? With respect to crime that has been acknowledged by the world under Rome Statute, there are only few crimes that have been listed over there under Section 4. If you read under Section 4 of Rome Statute, you have a set of crimes that have been acknowledged by the world that this will be constituting crime, right? And accordingly, measures will be made with respect to persecution of such an offender, right? Individual offender. Terrorism does not find its place over there, right? Or if murder does not find its place over there, those are war crimes, genocides, right? All those aspects which has been specifically referred under Article 4. It is also a very interesting statute altogether. International Criminal Court, Rome Statute, right? India is not party to it, right? We have certain reservations with respect to this. So, but it is forming part of public international law, and it is gaining importance in recent times, particularly in the light of the last year's judgment in the month of February with naming situation in Palestine, which is between Israel and ICC, right? So that is an important judgment, right? Particularly with respect to the status of the state of Palestine, right? So international criminal law is also gaining importance from that particular argument, especially with respect to jurisdiction matter of ICC, right? It's interesting aspect. So different set of legal systems between what we have in international law. Say, for example, other matters, you have ICJ. There are tribunals as well. Within the law of sea, you have a specific tribunal. And with respect to various other aspects, say, for example, WTO, you have a specific set of mechanism of addressing your concerns, right? You can place your concerns over there, and accordingly, a redressal mechanism has been provided by WTO. So is with respect to other organizations as well. So international setup does not have clarity with respect to as to what is the exact like court structure that you should be following in lieu of any problem that you have faced, right? They are differing to various extent, right? And many a times clarification is sought. With respect to jurisdiction of ICJ, clarification has been sought amongst the members of international law, right? And ICJ functions on this particular principle that state will come before it, right? Both of the states, if they come before it and they want to have, like redressal of their concerns, they will accordingly pass a decision, right? But that decision is not implicable upon other states, which who are not party to that particular issue, right? You cannot say that if there is a decision which had been enforced or been decided on the basis of two states, and it should be enforced against the interest of other states, right? So that's of like limitation we have with respect to that. So different setup, it affects differently. Within the contours of domestic law, you have direct connection of individuals, right, with the government. This is not with respect to international law. Individuals are becoming subject of international law, but we will still believe that it will take few more years, right? In terms of any repercussions that a person or a company obtains or seeks to obtain against another state, it has to be addressed through the state, right? So state will by and large be the party of international law. There is no reference of state versus an individual. There is always reference of state A versus state B under public international law, right? So that's a different setup. So legal setups are differing between the two states, right? Now, I have also said that violations, you can retrieve from any particular treaty, you can retrieve from any particular like declaration, provided the declaration has not obtained the status of customary international law. So your UDHR principle, even if you are not party to it, those will be applicable against you, right? Human rights and the entire jurisprudence of human rights thereafterwards have its roots to UDHR, right? or certain peremptory norms, which I've already informed that piracy, pirates, your slavery, right? Those all constitute parts of this. So you cannot, like dissolve your obligations with respect to these issues. But naturally, you have all the liberty of opting out from a particular treaty. But again, over there, the issue is, remember the concept of reciprocity. If you are opting out from any particular treaty, other state will also be following that particular practice against you. They will also have the justification. Since you can leave out from a particular treaty without giving any cogent justification to it, we also have that particular liberty. Reciprocity works over there in such situations. Right? Now, international law treats every state equal, right? You have United Nations, which does not distinguish any particular state on the basis of its capacity, its territory, right? A large state or a small state, they are all treated equally. A weak state is also given special status. No, similar treatment, not special status, but similar treatment, right? Or economically powerful state is not given any, like greater preference, at least in legal theory, right? There are selective states who have been receiving greater preferences compared to other states, right? And this has been argued time and again by various heads of these states before General Assembly, as well as through various court cases, right? But at least in theory, international law treats every state equal and grants them equal status, equal rights, equal obligations, right? There is no such selective favoritism to a particular set of states alone, right? Because many a times students do argue with respect to this that there is this Security Council which has been provided a special status, and they are treated differently. But that was a reason, and, and for that many a times we do not teach our students in that what should be the process of reaching to this particular conclusion and how should you proceed with it. Look at the history behind formation of UN Charter, right? And it is a very necessary requirement at that point of a time, though we will not be in agreement of that particular thing in present times, but it was found that only because of these particular states, peace upon the world will be prevailing, and they have succeeded in that particular extent, to that particular extent, right? Do we had any other third world war? And world wars were, like horrible. Like every state agreed that this should not be done, and that's what had been ensured by the Security Council. Like there are further other activities that they have done, right? In recent years, it has become more political, less with respect to the principle within the principles of international law, but more political in that particular nature, and therefore an argument which has been raised by many states, like with respect to its existence and justification for its continuing existence, right? But understand it from different perspective. Have it not stopped war? Have it not succeeded in ensuring that there is no another world war that took place? It has, at least till now. So it serves its purpose as well. Right? By and large, it doesn't distinguish us. Basically, the point is, right? So it primarily formulates, gives preferences to international agreements, right? Which ensures that international law makes sure that the international agreements in the form of treaties, like conventions, protocols, are rigorously followed, right? Ensure that the moment you became party to it through signature, right, as a signatory, those principles will be applicable upon you, and any violation of those particular principles will accordingly be dealt, right? Now, most probably in the next class, we can discuss from definitions. So this term was not found before 1789, right? Before 1789, the Roman terms, right? Us gentium and like us gentis, inter gentes, right? Those were the terms which were used with respect to international law. First time international law was coined by Jeremy Bentham, right? This is, and he uses this particular term, the mutual transaction between the sovereign states as such, and concluded that states are the sole subject of international law, right? So we'll learn about subjects of international law from this, that particular definition as well, in In the later half of the 19th century, the general idea is that international law is only between the states. This is not the scenario in present times, that international law is also been developing through international organizations, particularly your UN, right? United Nations. There's a case as well with respect to that, and we will be referring to that particular case. But first, we'll refer to various definitions and find out what they mean, right? So we'll stop at this point of a time. Any doubt or observation? Chalo, let me just download the attendance tab.